Welcome to Rapid Fire Wednesdays, Q&A for immigration professionals. I'm Kimberley Best Robidoux, a partner with WR Immigration in our San Diego location. And usually, as many of you likely know, I'm joined by Miki Matrician, who's the co-managing partner of our Boston office. Unfortunately, Miki can't make it today, so I am joined by Finn, our Director of Marketing. Good morning and good afternoon to you, Finn.
Good morning, Kim. I'm a poor substitute for Miki, but we hope she's feeling better and she'll be back soon so the listeners don't have to put up with me again.
Well, that, and, I just PERM part 3, people just, don't really like PERM. So it's a good one for Miki to miss.
All right, Kim. So you helped me out with preparing some questions that I'm going to tee up to you. So here's the first one. This is the time of year where there's a lot of mid-year promotions for our clients. We received a lot of questions from HR and global mobility professionals about the impact of a promotion on a pending PERM labor certification application. Let's say that we're in the process of preparing a PERM application and we're at the beginning of the process defining the job for which the foreign national employee is being sponsored for permanent resident status, aka the green card. Does a change in the job impact the process that has just been initiated?
Yeah, a change in the job definitely has an impact on the PERM process. So when we're, working with HR professionals, we like to explain that, the permanent resident position for which someone is being sponsored when we're going through the PERM process is based on 3 specific things. 1 is the employer that's doing the sponsorship. 2 is the specific job for which the person's being sponsored. And 3 is the worksite location. So if any of those 3 change, then it can have a significant impact on the PERM process.
So if there's a change in the job, what do you discuss with the HR global mobility team in that instance?
Yeah. So because the permanent resident process, when you're going with the first step being PERM, it can take a few years or even longer from the very beginning to the very end when someone becomes a permanent resident. The permanent resident process is prospective, meaning that we're looking at what is the position that someone is going to be in when they eventually become a permanent resident. And, when you're proceeding with the PERM process, nothing is ever guaranteed. But you want to determine, what is the best position that someone may be in the future, because you have this constraint on individuals with their career growth when you're going through the permanent resident process, specifically with starting out with the PERM labor certification process. So we understand that it can be really difficult to, kind of look in the crystal ball and figure out, what is that position someone's going to be in the future. But to the extent that we can determine that, then we recommend moving forward with a future role, if at all possible. If not, then we go with the current role, especially if it's likely that someone will be in that role for the foreseeable future.
Then what if there's a change in the work site when preparing the PERM application, like in the middle of that process?
So one of the things that we do look at, and we try to stay, really in close contact with our HR partners as we're working through the PERM process to understand, where is the person located? So because PERM is based on the geographic location where someone is going to be working, which is what Department of Labor uses in order to determine the prevailing wage for that position, we have to be very specific. So if we are at a stage in the process where we're defining the minimum requirements, then we just change the worksite location, right? We're just like, okay, they're going to perform these minimum requirements, but they're now going to be located in Boston, or they're now going to be located on the West Coast, or it's a completely remote position. So the wage will be based on company headquarters. However, if we already have a prevailing wage request that's pending with the Department of Labor, we have to submit a new prevailing wage request with that new worksite location, or the remote or telecommute or hybrid, whatever that is going to look like, because we have to have a prevailing wage determination that is specifically based on the geographic location of the employment. Or again, if it's remote, then it will have to be based on the corporate headquarters.
Yeah, a follow-up question on that then, I guess. Like if you're discussing, a worksite change with an HR global mobility team that you're working with, and an employee switches to 100% remote and can work from anywhere in the US, maybe because of the company's policy, would that be considered a change in work location? How does that all work?
Yeah, so it We have to look at where we are in the permanent resident process. So if we are not in a situation where we're at the last step, which is the adjustment of status, where someone is changing their status to a permanent resident, then it does require going back to the beginning of the PERM process in order to obtain a new PERM labor certification application that shows remote 100% work. So that is something that can trigger a restart of the PERM process or redo. With the current backlogs, that might not be a significant issue, right? Because there's already a significant wait time. And if somebody has an approved I-140 petition already, then they're not going to lose their quote unquote place in line because their priority date has already been determined.
Then this is another one that's unfortunately come up with a lot of companies in the last few years. But what about situations in which a company has a reduction in force or some sort of termination that's not for cause? What kind of impact does that have on the PERM process for an individual or for that company?
So with the PERM process, the employer is essentially conducting a test of the labor market or recruitment. So they have to determine if there are any able, willing, available, and qualified U.S. workers. There's another piece of it too that needs to be reviewed. And one of those is whether or not there has been a layoff, which is defined by the Department of Labor as, the termination of employment without cause. So if someone is terminated for cause, that isn't counted towards what is considered a reduction in force. But if there is a termination without cause, then we have to look at, was that person who was, or multiple people who were laid off, U.S. workers, and were they able, willing, and qualified for the position, which can require that the company actually take additional steps.
Yeah. So what are those steps that the company needs to take then when a reduction in force happens?
So they need to look at first, is that reduction in force in the same or similar occupation as the one for which the person's being sponsored? Is that individual at the same work site location? And it gets a little bit tricky, right? If it's a remote position, then essentially it's open season because it doesn't matter where somebody is located. So you would take a look at those particular issues. And if you have someone who appears to be qualified, based on their resume or what the company knows of their experience at the company, they need to determine if that U.S. worker who is potentially qualified is able, willing, and available for the position. Meaning, do they meet all of their requirements? Would they be willing to come back to the job if you were to offer it to them? But we're in a situation where there was a reduction in force. So is it really in the company's best interest sometimes to go through that process if they don't have those positions available because they just went through a RIF? But also looking at it from the perspective of, do you have multiple positions available in order to be able to bring that person back and continue with the green card process for the foreign national? If not, then what a company can do, because an organization is not forced to hire or rehire somebody, the company can make the strategic decision of, we just need to stop this PERM process and wait several months before we can kick it up again, which usually means getting a new prevailing wage determination and then starting recruitment over. So it's never a situation where a company has to hire somebody, but it can mean stopping the green card process for that particular individual or individuals, and it has a delay in the process. So there's a lot of strategic issues that go into an employer kind of looking at what's the best case scenario for them going forward.
Yeah. And then last question for me, piggybacking off that, in a lot of instances, HR and global mobility teams will be given the heads up, a few weeks in advance if there's going to be a reduction in force at the company. So they have a little bit of time to prepare. In that situation, what advice, what sort of framework do you recommend that they follow to prepare for the reduction in force when it comes to their PERM program?
If we're in a position where some PERM applications can be filed with Department of Labor before that RIF actually occurs, then that might be the best approach, is to move forward and file them as soon as possible before the RIF actually occurs. But, some things are regulatorily mandated. Every position and situation can be unique. So the best thing is to really talk through that particular situation with Immigration Counsel in order to determine, are we following the regulatory guidelines? Are we doing what is the best for the company as well as for the foreign national who's being sponsored, and what should our position be in this particular situation. So there's a lot of different factors to consider. Definitely file if at all possible before a RIF, but always go back and look at it from a strategic as well as a legal perspective with Immigration Counsel. That's all our questions for today, right?
That's all I've got. Yep.
Good. Cool. Well, everyone join us next week, June 12th, for our next installment of Rapid Fire Wednesdays. And no offense, Ben, but hopefully Miki will be back with us.
I hope so too.
Well, especially, you might want to talk with us about, the hot issues in I-9 compliance. That's always a fun topic to deal with. So if you don't already follow us on our LinkedIn page for WR Immigration, as well as Miki and my profiles. And then we also transcribe this recording into a newsletter, which we release on Thursdays. So please feel free to subscribe to that, and we will have the subscription information in the comments. We look forward to seeing everyone next week and dealing with another Rapid Fire Wednesday. Have a good one. Thanks, Ben. Really appreciate it.
Thanks, Kim. Bye, everyone.